Okay, well, I guess we'll get this started. I'm excited to see a good turnout. This is really great because most all of you are on land use boards, and of course, the more you know about the process and the laws and all that, the better the job you can do. So it's always very valuable to come to events like this and learn more about the law and the updates and the various idiosyncrasies that exist within our business here. I want to introduce Mark. I sent you all his resume, and I'm not going to go through all that stuff. But I just wanted to simply say that I think if you took a survey of land use officials and folks that are on commissions in the state of Connecticut and know kind of what's going on, to find out, who is maybe the top 6 or the top 12 land use attorneys in the state, but I don't think any of them would leave Mark off that list. I think everybody respects Mark incredibly, and I think a lot of the people would probably put Mark at the top of the list, frankly. And I think that's for 2 reasons. One is he knows his stuff. I've called him a million times. He isn't our full-time attorney here. We just use him a little bit for plan review, but he was my full-time attorney in New Hartford and Canterbury and whatnot, and I could call him with any question. He always had the answer. It was always the right answer. It wasn't always the answer I wanted, but he always gave us the right answer.
And sometimes a way around.
Yeah, workarounds. Yeah, so it always worked out well. He is the town attorney for several towns, New Hartford, and I don't know, he can rattle off some of the other ones, but he's town attorney for quite a few towns and for different commissions and stuff, so he's really, really well known. But the thing I think that really sets Mark apart is he does a ton of work pro bono doing training, such as this tonight. He's not charging the town anything for this. He works with Casio, which is the zoning enforcement officials group. He works with CACUIT, which is the wetland conservation group. He works with the Connecticut Association of Planning, American Planning Association. He works with those folks. Does multiple free trainings each year for them. And he's also one of the key kingpins for the land use training in Middletown there at the bar at the Wesleyan, which I know some of you have gone to. So he's really active, and I want to thank him for being so helpful to everybody. A lot of attorneys love to sue us when we do things wrong. Mark likes to help us so we don't get sued as much. So I want to thank him for coming tonight and for all that he does for our industry here. Thank you. And with that, I'll be quiet and I'll hand it over to Mark.
I could have just made one comment that both George and I have attested that you're so extremely helpful in helping us with the new registry. When we had all of that crap from Cincinnati to that, combining it and making it into a useful venture, I think you have attested that. I would say we're both grateful and very much impressed with your prowess in that particular area.
Thank you very much. Really appreciate it. I love to do these. I get asked. Steve asked me, so what do you charge for a seminar? I remember the first time I was asked that question. It was one of the few times I was actually speechless because I never charge for them. If I can do them, if I have the time, if I'm able to, I do them because I want the system to work. And the way that the system works is everybody knows the rules. Whatever side of a land use issue you're on, whether you represent a commission or a developer or a neighborhood group, you want the system to function. You want it to operate the way it's supposed to. And that's why I think that these things are so important. The thing I'm going to focus on tonight are the procedural things that are common to all kinds of land use agencies, whether you're ZBA or wetlands or planning and zoning. Where they're different, I'll highlight that. But the reason that this is so important is because many court cases say that a judge is not to substitute his or her judgment for yours. If you are also the finder of fact. So if you hear conflicting evidence, you're allowed to believe whoever you want. For that reason, the only way that a commission can lose an appeal is 1, by not following the correct procedures, or 2nd, by doing something that just isn't authorized by the statutes. Okay, just not statutorily authorized. We're not going to get into that second class of things. What we really want to go after is making sure that you're following the correct procedures when you're making your decisions, because 90% of the time, you're going to be okay then. Every town wants to save money. They want to save money on attorney's fees. One of the ways you save money on attorney's fees is by discouraging appeals. And you discourage appeals by winning, and you win by doing the right procedural stuff. So we'll start with that. This PowerPoint was put together by Bruce Hyde from the Connecticut Land Use and Education Research. We very much appreciate it. I don't know how to do any of those things.
Just stop, I don't know.
Maybe because, now is it happy? This is why I don't trust them. What do we have to do to get it happy again? Because I'm seeing it on screen. I have it here.
Do the mirror button.
Sometimes you gotta hit the.
I don't know. I know when I came, did it say something? Press off, no. Signal. There we go, all right. I'll have to move it at a pace that it's happy at, okay? So, the courts can't substitute their judgment for yours, they can't substitute their facts. If your regulations are authorized by statute, and if you apply those regulations as they're written, and if you have the evidence to support your decisions, you're going to win. You're going to win the appeal. I'll tell you, some years ago, I was involved in a Walmart application. I often refer to these, by the way, as the Walmart applications, by which I mean the controversial applications. It was a wetlands application in Cromwell. It went on for several nights. There were 2 attorneys in opposition, 1 attorney in support. I was representing the town. And at the end of it, the commission approved the application. And I went up to one of the neighbor attorneys who I knew and said, so, are you going to appeal? And he said, Mark, you didn't leave me a crack any thicker than a dime. I said, thank you. That's what I want to hear, and that's what we all want to hear, okay? The other thing you need to be aware of is what's called procedural due process. This is something required by the U.S. and Connecticut constitutions. It means that the way in which you are reaching a decision is the right process. Not that you reach the right decision, but that you use the right procedures in getting there. And the touchstone to procedural due process is fundamental fairness. Those are words you have to keep in mind. Fortunately, this is not a very technical concept. When the courts use the term fundamental fairness, pretty much any of you will understand what that means. And we're going to sort of walk through some examples of what involves fundamental fairness. But it really is a pretty, if it doesn't feel fair to you, you're probably right. It's a gut kind of thing, and it doesn't seem fair. This is different from substantive due process. Substantive due process is that you reached the legal conclusion, all right? That you followed the substantive law, that you didn't do something that's prohibited by the Constitution or by law. You will very rarely run into substantive due process, okay? Because all of you have regulations that are authorized by statute. So as long as your regulations are in conformance with the statutes, you're not going to be able to create any substantive due process problems. So where you're going to run into the constitutional issues is the procedural due process, okay? Now, pre-application conferences, you don't have to do these. ZBA, you really can't. Planning and zoning, wetlands, you can if you wish. The statutes now expressly authorize it, so does case law. Case law authorize it first. Basically, the purpose of that is before the applicant's plans get too firmed up, all right, that they can meet with you to identify major issues. The hope is, first of all, that you will avoid ambush. I don't think anybody wants to ambush an applicant. You know, you didn't bring a traffic engineer. We always want a traffic engineer. Well, how are they supposed to know unless it's in your regulations? So to identify what are the possible issues, what would you like the applicant to address? I was recently involved in one for one of our client towns, where at a pre-application conference, the commission said, we'd like you to specifically address how this relates to our plan of conservation development. So, okay, so the applicant then was prepared. They knew that's something the commission wanted them to address as part of the formal process. They can be done with staff, of course, That's routine. I think in every town, an applicant meets first with your planner or wetlands officer, whoever the staff person is, to find out, are there particular things this commission is worried about, particular things they usually look for, that kind of thing. But I think it's a beneficial process because it allows the applicant to respond to things before they've gotten too far down the pike. Once an applicant has designed all the stormwater drainage and the grading and has spent tens of thousands of dollars on engineering, and they show up for their formal application, at that point when you say, gee, it would be nice if the building was in the front and the parking was in the back, instead of the parking in the front and the building in the back. Perfectly good idea that they would have accepted, perhaps, if they had known before they did all that engineering. But once they've designed everything to the final nail, then they're not going to want to make those kinds of changes. So I think pre-application conferences are valuable. The one thing you need to watch out for is avoid predetermination. And we're going to take some time on just predetermination and conflict of interest, because again, those are things that affect all boards and commissions. Predetermination basically is where your mind is so made up that no matter what evidence you hear, it's not going to change your mind. This is often a problem with elected commissions. Someone wants, someone's running for a planning and zoning commission, and you're at a rally or a meeting, and someone says, if I vote for you, will you promise me that you'll vote against Walmart? Once you say yes, I promise, if I'm elected, I'll vote against Walmart. Well, guess what? You're not voting against Walmart because you're disqualified, all right? You can't make statements like that. That's predetermination. And I'll give you some more examples of that when we get there. Application fees. One of the things to remember is it's Connecticut General Statute Section 8-1C authorizes you by ordinance to cover all of the expenses of your reviews, your consultants, experts, in-house staff, secretarial, clerical, transcripts, legal fees. You're allowed to recover all of that from application fees. Many towns don't do that, or don't do it to the extent that they should. A wetlands commission can do that by regulation only. A planning commission can do it in their subdivision regulations only. But for zoning, it has to be an ordinance. Right? 8-1C ordinances can be for wetlands, planning, and zoning, all three, all right? But the zoning commission can't adopt these fee arrangements without an ordinance. If you
do have that.
You have that, good. Very important. I represent developers as well. I did one very large project where the reimbursements to the town for consultants' fees were $450,000. And my client said that was the best money he spent on the project. It was a $49 million project. And the commission had complete discretion to say yes or no. And those consultants gave the commission the comfort level to say yes. And without them, we would not have gotten an approval. They reviewed everything we submitted. They agreed that our engineers and traffic engineers and all of our experts had done their jobs, and that allowed the commission to say yes, and that project is now built and occupied. So it's good for the developer to pay for these things as long as you're hiring competent people, but it also takes a burden off the taxpayers and allows you to get the kind of expertise and support that you need. This is particularly true for do we have wetlands people here tonight? Any wetlands? No wetlands. One wetlands. Okay. All right. So it's a very valuable thing to be able to do. The thing I would say to you also about application fees, or anything that's an incomplete application, treat every application as a live bomb, okay? If the application is incomplete, deny it as incomplete, because otherwise your clock is running. In the case of subdivisions and site plans, you have the risk of automatic approval. You don't have that with special permits or text amendments or wetlands. ZBA, you never have automatic approval. But for your subdivisions and site plans, you're risking automatic approval. I'll tell you, some years ago, one of our client towns, the town of Westbrook, was just constantly getting incomplete applications. It was just absolutely routine. As you can imagine, it was one or two particular engineering firms that were doing this. Again, as I said, I represent developers myself.
I've had my developer clients say to me, look, just file something. You know, I don't have it all done, but just file something, get it in there, and, you know, get started, which is a terrible idea. It means that your reviewers don't have a complete set of plans. The clock is running for you, and you don't have everything you need to review. And what they did in Westbrook was that they began to set their public hearing on subdivisions. They would see what was missing, open the hearing, list the missing items, and deny the application is incomplete. Just deny it. Make them start over again with a new application fee, and pretty soon people stop doing that. Applications should be complete when they're filed, but if they aren't, you have to act on them. Okay, the fact that they're incomplete does not hold your time levels. Alrighty. We talked about procedural versus due process versus substantive due process. What you're doing is you're comparing the application against the regulations that you have adopted. This is why having your regulations say what you want them to say is so important. I cannot tell you how many times I've been in a situation, either as a town attorney or as a developer's attorney, where you say, well, this complies with the regulation, and the commission says, well, we didn't really mean that. You know, that's not written correctly. Yeah, well, maybe it isn't, but it's what it says, and you have to apply it as it's written. You want to conduct your hearings in a way that no one is intimidated or harassed or disadvantaged. This, and again, with controversial hearings, this can be difficult. People applaud, they boo. This cannot be allowed. People need to feel that they can be heard without being heckled or intimidated in any way. Crowd control is critical, all right? If there is an atmosphere of hostility, so-called, that's a quote from a case called Thomas versus West Haven, it can invalidate the proceeding. That's not a good thing, but more important, it can produce a civil rights action against the town with money damages. That's what happened in the Thomas case. The town didn't just lose on appeal. The town was sued in federal court and lost, and was forced to pay money because they had allowed an atmosphere of such intimidation to occur. And what happened in the Thomas case is interesting. It was only 2 commission members who were just off the reservation. I mean, they were just being crazy. And when the town was sued, the town said, well, to the court, they said, you know, we can't help it if we have 2 bad apples. It's not our fault that 2 commission members acted like this. Everybody else was nice. And the court said, yes, it is your fault. You are the town. It is up to you to control this. It is up to you to create a fundamentally fair hearing, and how you do it is not our problem, all right? Whatever you had to do to shut those guys up, you had to do it, okay? Jokes. One of the things I often say is that jokes and sarcasm do not transcribe well, all right? One of the seminal cases there was a situation. I don't know if any of you know George Logan. He's an environmental consultant. He's a nice guy. He's a pretty pleasant fellow, okay? Great sense of humor, all right? He was representing an applicant. So he was the applicant's consultant. I emphasize that. And he joked. The application was for a garden. You know, it was a wetlands application. And he joked to the commission, you know how Italians love gardens. And the commission joked back. And on appeal, it was not funny. The court said, I'm sorry, there was an atmosphere of hostility created for people of Italian descent. I believe it was unintentional. I do not believe the commission meant to do that. But nevertheless, some jokes aren't funny, and there's a place for jokes and there's a place for no jokes. So sarcasm and jokes do not transcribe. They are not for commission hearings. And as I said, there is a potential for a civil lawsuit, for damages. You want to require that all comments be directed to the commission. One of the things that begins to happen, people start to shout at each other across the room. You will hear me say this in many different ways, many times. Once things get out of control, they spiral out of control fast, okay? So people have to understand, they address the commission, not each other. Never allow anyone to interrupt a member of the commission, especially the chairman. I would say that is especially true for those of us who should know better. Lawyers, engineers, people who appear before you routinely. Steve has seen me do this. When I am in the room, if someone interrupts a commission member, I will say, never interrupt the chairman. Just like that. And I mean it. Because otherwise, again, once you let it get started, then somebody else shouts out from the back too and wants to interrupt. No one speaks unless they're recognized, right? No hubble bubble out in the crowd. Try to keep people on point. I know this is hard. I was telling Steve earlier about a wetlands hearing that I attended where everyone wanted to talk about the traffic and the character of the neighborhood. Like, no, this is a wetlands commission. There will be a planning and zoning hearing where you can talk about those things, but we're not there yet, okay? One of the words of caution, not to run too late at night. My personal record is 20 of 3 in the morning. My wife always says to me when I get home at 1:30 or 2 o'clock in the morning, she says, how can they be making good decisions at this time of night? And my response is, who says they're making good decisions at this time of night, okay? At a certain point, tempers get brittle, people say things that don't look good in the transcript, things start to get out of control. You're better off to quit at 10 or 10:30, adjourn till the next night, the next week, whatever, rather than be going till midnight, 1 o'clock in the morning when people get crazy, okay? If you're expecting there to be an appeal, if you expect it to be controversial, have your attorney there, all right? I would always rather be at the hearing than try to fix something later on, all right? And again, I said, you save money by winning appeals. If your attorney is there with you when the problems are happening and can fix them, it makes it a lot easier to win later on. You don't save money that way. Set out the ground rules for people right at the beginning. We'll hear from the applicant first. Oh, by the way, that's not a requirement, but we indulge this quaint notion that people want to hear what the application is before they tell you why they're against it. Okay, it's just one of those little fictions that we try to stick with. Okay, so we'll hear from the applicant, questions from the commission, staff, those in favor, those opposed, those who don't want to be categorically either. Now, some towns have all those in favor speak and then all those against. I've also seen towns where we'll have one person in favor, one opposed, one in favor, one opposed, until we run out of one or the other. Either one of those are fine. Doesn't matter which system you want to use. The key is that everybody gets heard at some point. One of the things I'm going to mention here are time limits. Some towns say no one can speak for more than 3 minutes or 2 minutes or something like that. There is one court case on that. The Connecticut Appellate Court held that was all right where the chairman limited everyone to 3 minutes for the first time at bat. Then when everyone got their first chance, you could get a second or third time at bat with no time limit. And the court upheld that. They said, look, he was trying to get the most number of people to be heard the first night, all right? Everyone did have a chance to, because they challenged on it. They said, this isn't fair, I only had 3 minutes. The appellate court said, no, you had 3 minutes the first time. After that, you could speak as long as you wanted to. And one of the things the court pointed out was that by the third night of public hearing, at about 9 o'clock at night, the chairman asked, is there anyone else who wishes to speak? And there wasn't. So the court said, clearly everyone did have the chance. Notice the difference, though, if the chairman had said 3 minutes and no second chance. I don't think that would have been allowed, all right? The key thing is to try to keep people on point, to keep people, yes?
Is that a court case or was that statute?
That's a court case. That's an appellate court case.
Do you know what the case was?
I have it here, so I can find it for you. Yeah. Some of them I have memorized, but I don't have. But I have it here, so I'll get it for you. So time limits. Alrighty. The other thing you want to, no shouting, no applause, no booing or heckling. Make sure people understand that they will be evicted from the meeting if they don't follow those rules. The Freedom of Information Act does allow you to eject people from a meeting if they are being unruly. We had in one of our client towns, we had a hearing on a proposed Islamic cemetery. And Steve remembers this one. And the only thing missing were the white sheets and the burning crosses. I mean, people were out there vicious and nasty, and we had a state trooper there, and I made it very clear that anyone who made snarky remarks was going to be out of the room immediately. Okay? You've got to be very, very clear with that. Keep the applicant in line. Some applicants want to incite the crowd, all right, because they're planning on suing you later on for civil rights, all right? That is especially true for affordable housing applications. Some people will deliberately try to goad people into making racist remarks in an affordable housing application. Don't fall for that, okay? Cut them off. Please, attorney so-and-so, please keep to your application. Please avoid characterizing this community or future residents thereof, okay? Chairman, keep your own troops in line. I know this is hard. Sometimes maybe you need the first selectman or the chairman of one of the political parties or the town attorney. In one of my towns, we had one guy who kept saying things on the record that were just poison. And so I took him to dinner the night before one of the meetings, and I walked him through and I explained it all. And yes, oh, thank you. Yes, okay, I got it, great. And we both drove to the meeting, and he did exactly the same thing again. All right, you do the best you can. Avoid the mob mentality. Have the police on hand if need be. All right. We had a hearing, I won't tell you what town it is since this is being televised, but it was a gravel pit application. And at a certain point, well, the chairman knew it was going to be controversial, so he had a state trooper present. And at a certain point, things got out of hand. The crowd mobbed the state trooper and pinned him against the wall in the hallway. A state trooper. They adjourned the hearing, and when they reconvened 2 weeks later, they had 3 state troopers. If that's what you need, do it, okay? Because like I say, this stuff really goes fast. Have a large enough room, okay? Oversized is better. When people are crowded into a room, there's a sense of anonymity. Somebody, the voice in the crowd, and you can't really tell who it is that's speaking. Be sure that you have a way to display plans. I have been in so many meeting rooms where there's no bulletin board or something. So the engineer turns the tripod toward the commission, and the public says, I can't see, which is legitimate, all right? So you turn it toward the crowd, and the commission says, well, now we can't see. You know, have a way to do that. If you're ever, not that you would ever be in the neighborhood of a commission meeting in Newington, but if you are, Newington, and actually also Vernon has this as well. They have large flat screens on all the walls, and everyone who comes to the commission has to bring all their stuff on a USB, on a thumb drive, and it's all projected on screen. So wherever you're sitting in the room, and the guy has a cursor, pointer, he points it out. It's a very good system. Of course, it's money, but it's worth it. Have an audio visual system. I will promise you, someone will sit in the very back of the room and shout, I can't hear, move up front, but have an AV system again. This is for the controversial application. All right, so applicant speaks first, proponents, opponents take turns. You may occasionally get an intervention, a SEPA intervention under 22A19. I'm not going to get into those in too much detail, but if you get one, call the town attorney. Okay, it gives those people the right to speak, even if there is no public hearing. All right, it's a right of intervention. The chairman can allow people to speak even if there is no public hearing. All right, you don't have to, but you can if you wish. So if it's a site plan and there's no public hearing and someone wants to say something, you're allowed to let them do that. Cross-examination. This is one that is a source of a lot of confusion. The law is very clear. People are allowed to cross-examine those who testify at a commission meeting. Simple as that. Most of you have never seen it, which is fine. If you do have somebody who stands up and says, Mr. Chairman, I want to cross-examine that witness, chances are it's a lawyer. By the way, it doesn't have to be. Anybody can do it. But chances are it's going to be a lawyer. And it's going to be a lawyer because he or she is hoping that you'll say, no, we don't do that here. And then they're going to win on appeal. So it's a trap. It's a trick. And don't fall for it. You say to the person, well, we're a small town. We do things kind of informally around here. Would you mind asking your questions through the chair as opposed to that Perry Mason style? Is it not true that, Now, the lawyer or the person has a choice. They can say, yes, Mr. Chairman, I'm willing to do it that way, in which case they have waived the claim and cannot appeal on it. And if they say, no, Mr. Chairman, I demand the right to cross-examine that witness, then let them do it. Nothing good ever came out of a cross-examination, okay? So if they want to do it, just let them have their fun and avoid the successful appeal. All right? Site walks. We don't have any wetlands people here, so I'm going to skip a little quick over the normal. Some commissions do have site walks. Now, ZBAs. Usually when you view a site, you are viewing it from the street or from some other place the public is allowed to go. You can do that, all right? As long as you're viewing something from a public location, you can go out one at a time or two at a time or any way you want to, and you're going to be all right. The reason this arises most with wetlands and with zoning commissions is if you're going to be tromping through the woods, all right, the Freedom of Information Commission has ruled many times that you have got to allow the public to go with you. It's got to be a meeting, all right? You can't go out in twos and threes to circumvent the public's right to know. So if you're going to walk a site that's, tromping through the woods, have it as a meeting, posted with the clerk's office, allow the public to attend. If the developer says, I'll let you go, but I won't let those members of the public go, then the answer is that nobody's going, right?
Even if it's just one or two members that want to go out, if they're going to be going off the road or going into the woods, like it has to be a meeting, because I've always understood as long as there's not a quorum there, that they can go look.
What the Freedom of Information Commission has upheld is, for example, one of the cases that they ruled on, the chairman and the town planner walked a piece of property, and then they reported back to the rest of the commission at a public meeting at which the public was in attendance. That was found to be okay. But what was not okay was when out of a 7-person commission, 2 went today and 2 more went tomorrow, and then 3 went the next day. So in fact, they all went. A quorum of them went. And they used that information in making a decision, but the public could not see whatever it is that they saw. That's what FOI won't allow.
So if a quorum shows up, then...
If a quorum shows up,
anyway.
however you configure it, okay, then you've got an illegal meeting. And again, fundamental fairness. A friend of mine is a surveyor, but is also a member of a wetlands commission in Connecticut. And he argued with me about this. And I said to him, why do you walk properties? Why do you go? You have topo sheets, you have plans. He said, well, I found that to really get a feel for a piece of property, this is a surveyor speaking, okay? No set of plans is as good as walking the property. I said, okay, so what you're telling me is that in reaching your decision, you look at the plans, but you get something extra from actually walking the property. He said, that's right. I said, and whatever it is that you get from walking the property, you use in making your decision, right? He said, right. I said, and yet you're precluding the public from having that same additional information that you think is so valuable. If you think it's valuable to know it, then the public has the right to know it. Whatever you see, whatever you hear, whatever you know, they're supposed to see it and hear it and know it too. So everybody is on the same page. Everybody has access to the same body of knowledge. And if a site walk gives you knowledge, then the public has the right to be aware of it. So that at least is the position of the Freedom of Information Commission. Frankly, I agree with that. If you're going to have a site walk, you will find it is impossible to record them. The wind and the microphone, it just doesn't work. I've tried it. So save up questions and comments until the hearing opens or reopens. If a commission member can't make a walk, they can make that up as long as they go wherever the other commissioners went. All the commission members have to stay together. They can't scatter across the site. Now, for testimony at your public hearing, everyone has to identify themselves. Many commissions have people sign in. Freedom of Information Act says that you can't require people to sign in to come into the room. All right? But you can require people to sign in to speak. If for no other reason than that your secretary knows how to spell their names, puts them correctly in the minutes. Once you close the public hearing, then there's no new evidence, no new testimony from any interested party, and no new issues. All right, commission members should not testify. You are there to listen. Listen to the experts, the arguments, the evidence, whatever, and make a decision. If a commission member has special expertise, you're an engineer or a surveyor or a botanist or whatever, okay, you should disclose that so that, again, fundamental fairness. Everybody knows that this one commissioner is not just a layman, all right? Some years ago, I was the president of the library board in our town, and we were doing an addition, and we needed to present a wetlands application. So I was working with the engineer to do our presentation. The engineer said, these wetlands commissions, you can't get into too much detail. They, their eyes just glaze over. I said, do you know who's on the Glastonbury Wetlands Commission? He said, no. I said, well, the chairman is the former environmental vice president of Northeast Utilities. The vice chairman is a civil engineer who's on the National Board of Directors of the Nature Conservancy. Then there's a retired geohydrologist with the USGS. And I just went on listing these people, okay? I said, so you better be ready to get deep into this and for some tough questions. Another member was the director of the local Audubon Society Nature Center. And this was a really high-powered group of people, all right? But people need to know that so that they gear their testimony to the audience, all right? Let's see what else. Demand that you be treated with respect. To me, this is a biggie. I always commend commission members. I know that after 10 o'clock you get time and a half. Sometimes you get double, right? Double your normal hourly rate, triple. It could be any number you want to pick, right? You do this for the love of your town because you're trying to help your town, but people should treat you accordingly. And if people are rude, then they should be dealt with. One of the things that I have done, you don't have to do this, but just my personal thing, is if someone is being rude especially for an applicant, and especially if it's a lawyer who should know better, right? I will say to the chairman, Mr. Chairman, Mr. Smith seems to be very excited or very tense about this. I think perhaps what we should do is table this item till the end of the meeting, so he has the opportunity to compose himself and collect his thoughts. And then you just let him sit there while you do minutes and committee reports and stuff like that, and the message gets across pretty quick, okay? Always treat your staff with respect. Whatever differences you have with your support staff, do in private. The public needs to feel that staff person is your representative, your protector, and that's how they are effective. For exhibits, again, this is the big application I'm talking about, not your small routine one. You should indicate exhibits that have been received. You do not have to read them out loud. You do not have to read letters out loud. You can just say, we have exhibits A through F at this time. They consist in general of the plans, whatever it is, just a summary, okay? People need time to evaluate that. You need time to evaluate an applicant's materials. This is another reason why an incomplete application is such a problem, because you're reviewing it in bits and pieces, and you should not be required to do that. There is one interesting case where the developer appealed on the ground that there was so much information, and the court's inquiry was, well, did you not have time to review it all? Oh yes, no, we had plenty of time to review it, but there was a lot of it. And that wasn't fair. all right? And the appellate court said, so the volume of information makes it not fundamental fairness. That's a concept they weren't buying, okay? As long as people have the chance to review it, a reasonable opportunity, whatever that is, you're going to be okay with that. There are certain things that have to be read out loud. I'm not getting into this. It depends where you are. In some areas, like gateway reports, CAM reports have to be read out loud. Regional planning agency reports on zone changes have to be read out loud. But the statutes do that. Electronic presentations, PowerPoints, okay? Most commissions require that they be submitted in hard copy also. And that's so that when someone comes to Steve's office and says, I want to see that PowerPoint the developer showed last week, he doesn't have to take up a computer screen. You know, here's the hard copy. You can look it through that way. And they're all pretty good about doing that. Staff input, okay? The normal rule is that your staff can speak to you after the close of the public hearing. That's the general rule. However, even staff cannot bring in new facts or new issues, whole new issues. Again, fundamental fairness. It's not fair to the proponents or the opponents if new information or issues are raised after no one can comment on them, after the hearing is closed. You are never bound by staff opinion. You'll often hear people say, well, your planner recommended this. Well, that's his opinion, okay? You are the commission. You can make whatever decision you want. ZBA folks, exception to the rule. When the ZEO's decision is being appealed, the ZEO is an interested party. Therefore, you cannot hear from the ZEO after the close of the public hearing where his or her own decision is being appealed. Right? That's an exception to that, speaking after the public hearing. I'll give you a quick example of this. That was some years ago. One of my client commissions had heard an application for a dog kennel, and the developer had brought in an acoustic engineering study to evaluate whether the noise would be objectionable. And after the hearing closed, the commission said to me, we'd like our own acoustic engineer. Well, that really was a bad idea. But I called an acoustic engineer that I know, and I told him, I'd like you to review the applicant's report. Just review it. Tell us if it's valid. He said, oh, Mark, I can do better than that. I just got a hold of this new study about dog kennels and the noise from dog kennels. I can give you that report. I said, no, you can't. That's new information. All you can do is tell me, is review the applicant's submission, and as commission staff, tell me if his methodology was correct, if it was done as a proper acoustic engineering study. That is all that you can do. And I think that highlights this distinction between staff review and new information, okay? It's a good idea to number exhibits where there's a lot of them. You don't have to, okay? One of the reasons for that, again, on appeal, you will see transcripts where the developer's engineer is speaking, and he says, now, you'll see on this plan over here that how I drew this. But on this one over there, you see how it's different? And this is meaningless to somebody listening to a transcript like that, all right? So you try to prompt people testifying and say, I think you're referring to the site plan, sheet 205. Oh, yes, Mr. Chairman, yes, sheet 205. That's Exhibit A, I think. Okay, and just, again, also an absent commissioner who listens to the transcript to have some idea what all this stuff was about. There are hundreds of cases that talk about substantial evidence. This is a topic we could spend the night on all by itself. The courts require that every decision that you reach be based on substantial evidence. Substantial evidence means that it is probable that something will or will not happen. Speculation is not substantial evidence. If you've been on a commission long enough, every one of you have heard the testimony that, if they build that subdivision and an oil truck turns over there, and then a meteor strikes the oil truck, and then, oh, come on, that's not evidence. That's speculation, all right? I'm afraid that there could be an accident. None of this is evidence. Courts will not support your decision without evidence. So substantial evidence means some indication based on rational fact that something is reasonably likely to happen or not happen. You'll get this a lot with experts, right? When experts testify. Experts may say to you things like, I'm worried that, or there's the chance that, or there's the possibility that, or there's the risk of. None of that is substantial evidence. Substantial evidence is, in my professional opinion, it is reasonably likely that the following will or will not occur. That is substantial evidence, okay? The burden is on the applicant to provide that substantial evidence to show compliance with the regulations. The only place where that is not the case is with affordable housing 830G application, where the burden is on you. That's a night by itself. We're not going to get into that too deeply. Expert input, okay? You will hear people say to you that you must believe the testimony of an expert. That statement is false. It is only part of a statement. The true statement is you must believe the uncontradicted testimony of an expert unless you have reason to disbelieve the expert and state that reason on the record. And I'll give you a quick example. I served a 7-year sentence on the Planning and Zoning Commission in my own town. And during that time, we had a traffic engineer testify about a particular proposal for a convenience store gas station. Very good traffic engineer, by the way. He, of course, testified that this development would have no adverse impacts on traffic flow. And I said, are you aware that the northerly driveway for this project is to be shared with an already approved Jiffy Lube operation? He said, no, I wasn't aware of that. I said, are you aware that that same driveway is also subject to an easement in favor of a developer proposing 64,000 square feet of retail space to the rear of this location? He said, no, I wasn't aware of that. I said, are you aware that a Home Depot has been approved about a quarter of a mile away northwest of this site? He said, no, I didn't know that. I said, and are you aware that 2 5-story hotels have been approved and not yet built about a half a mile southwest of this location? He said, no, I didn't know that. I said, I want to state for the record, then I find your testimony not credible because your client has failed to inform you of the context within which this development is being proposed. And based on what is going on around this site, adjoining it and using its very driveways, I don't agree with your assessment. I believe there will be a traffic impact. I didn't just say, I don't believe you. You're lying. I had a reason. I had reasons why I did not believe him. If you have expertise, if you're an engineer or soil science, whatever, you can do that also. You can say, as a fellow engineer, I find your testimony not credible, and here's why, okay? Whenever you have a technical issue, get testimony on both sides. Hire an engineer. You have in-house engineering here? No. And if you have consulting engineer, again, for the controversial application, get testimony all around. Who gets the last word? Typically the applicant, because they have the burden of proof. But even the applicant cannot bring in new issues or new facts as part of their rebuttal. So that last word has to be a summary of the points that have already been made. Tape everything, record everything, including deliberations. I think everybody does this now. A lot of commissions used to tape only their public hearings and not their deliberations, and the law has always required both. Lack of a proper transcript could have it remanded back for you to do the whole thing again. I had that happen once in my career, where the tape failed and the court had us go back and try as best we could to recreate what everybody said that night. It was awful. Speak up so the tape can hear you. I've been in so many commission meetings where they're mumbling, side conversations. It's, first of all, again, not fundamental fairness. The public should hear what you're saying. All right, you're the decision maker. But also, it doesn't record very well. Other people are allowed to tape or record your meetings as long as they're not disruptive, okay? So as long as you're not poking a camera in your face while you're trying to watch something, people are allowed to record the meeting. Commissioner expertise, I mentioned this, okay? You may rely on your own expertise for, first of all, general subjects. This came up in Old Saybrook years ago. The traffic engineer had used the DOT standard seasonal adjustment factor of 20%. He took his traffic counts in January in Old Saybrook. And then he added 20% for summer. And the commission members laughed out loud. I mean, they actually laughed. They said, 20%? You know? You don't live around here, buddy. Commissioners are allowed to use their knowledge of traffic conditions where they live. That's not a matter of expertise, okay? If it is a matter that does call for some special training, then okay, you have to have people who have that. Experts can be subject to cross-examination, as I said before. One of the things that they do in Willington that I recommend to all of our client commissions, because Willington adjoins Mansfield, Yukon, Willington has a stunning number of really expert people on their volunteer boards and commissions. Their wetlands commission has Connecticut's top botanist on it, as an example. So what the planner there does, she just retired, terrible loss. Whenever she opens a file, any file, she automatically puts in the resumes of any commission members that have expertise in engineering or biology or whatever. So that way, nobody has to remember to say it. I just want to know for the record that I'm a botanist. Okay, you don't have to do that. The resume is in the file. So if you have people like that, it's a good thing. Just plug it in. Remember that you only consider the things that are said during the public hearing. No facts that are later on. No surprises. No ambushes. You make your decision based on the evidence that you heard and the criteria that are in your regulations. Those regulatory criteria can be discretionary. You know, character of the neighborhood and things, undue traffic, those are allowable criteria in most zoning situations. In cases where your regulations are unclear, you are allowed to interpret them. Courts will give some deference to your interpretation of an ambiguous regulation as long as, one, it is reasonable, I put that in quotes, reasonable. Second, as long as you have consistently applied it that way, and there's evidence on the record that that's how you've read it for a very long time. The courts don't have to accept your interpretation, but they often will. If they feel that you've been interpreting it different ways depending on who you wanted to win, all right, then they're not going to back you. Zoning commissions, you cannot waive regulations. Even if it's in your book, you cannot do it. That is the McKenzie case. All right. If you want to get deeply into the McKenzie versus Santa Sierra, we can do that, but I'm not going to go there right now. So when you reach deliberations, the three questions you ask: what evidence did we hear about this particular criteria of our regulations? What do we conclude from that evidence? Were the criteria met? I had one very difficult case where the commission's decision was certainly very questionable, and it was challenged on appeal. And the commission spent 2 nights going through each component of the regulation and asking what evidence did we hear on this, and discussing it line by line. And when we got to court, I said to the judge, I challenge Your Honor to read that transcript and conclude that this commission was being arbitrary and capricious. And the judge agreed. He said, I probably wouldn't have reached that decision. But this commission spent like 5 hours reviewing the criteria and all the facts they heard, and I'm not allowed to substitute my judgment for theirs. And we prevailed on what was really a very difficult case. Okay? Always have some discussion. All right? Don't just all those in favor. I mean, again, on the controversial application, you've sat through 5 hours of hearings, and a hearing closes. Do I hear a motion? Move to approve. All those in favor, aye. You know, judges they'd like to have some idea after all that back and forth for 5 hours what you concluded from it. So try to have some kind of discussion. The decision, okay? Sometimes you will deny without prejudice. Now, I had a judge tell me there is no such thing. I don't agree. A denial without prejudice means the application was incomplete, or there was a faulty legal notice, or for some reason you were not able to reach the merits of the decision. That can happen, all right? Statements of reasons. All the statutes say that you shall, it's a magic word, you shall state your reasons. The courts have said that that word shall is what's called directory rather than mandatory. So if you don't state reasons for your decision, the court will search the record to find them for you. Good deal. Problem is, if you do state your reasons, the court looks only at the ones you stated, no others, even though there might be better ones. Right? The court won't look at that. The moral of that story is, if you're going to state reasons for your decision, state them all. All right? Work with your planner and your attorney. And there is no such thing as a motion that is too long. I think my record was 52-page approval motion. Right? We found every single thing. All right? Reconsideration. Basically, you can't. If your decision has been published, you cannot reconsider, period. If your decision has not been published, the courts have held that you can reconsider for a good reason, whatever that means. Precedent, a lot of times you hear this at ZBA, well, you gave him a variance, now you have to give me one. The courts require you to be consistent, to apply and interpret regulations in a consistent manner. But precedent is difficult because every piece of property is different. So the fact that you may have approved one or denied one doesn't necessarily mean that if something is similar, that you have to do the same thing. That is not the way it works. Your post-decision legal notice has to be precise, and again, that's something your staff worries about. Time limits, be aware of your time limits. Important, if you're amending your zoning regulation or text, you must set the effective date in the motion, right? Otherwise, it's invalid. So zoning text or subdivision text amendments, wetlands text amendments, you must say what the effective date is, and that effective date must be no earlier than the date of publication. So allow enough time for that legal notice to be published as to when that new regulation is going to be effective. Conditions and modifications, we could spend a night just on that. You are allowed to approve something with modifications or to condition it on certain things. A lot of times this is a way to sort of fix a defective or improper application without starting over again, if it's something that's readily fixable. The point, however, is you don't have to do that. The issue I phrase it is to fix or not to fix. You don't want to so modify an application that it bears no resemblance to the one you went to public hearing on. That may not be considered fundamentally fair. Some member of the public may say, or the applicant may say, if I had known you were going to make so many changes, I would have made different comments. Legit, right? So conditions and modifications should not be used to remake the application, but to address issues that are resolvable, that are fixable. The stating of the motion, if staff don't do these for you, take your time drafting a motion. Again, on the controversial application, the motions of approval or denial. Work with your attorney if you know it's going to court to make sure that that's a very complete thing. Remember that once you vote on it, it cannot be changed. I just had a case recently, I won't tell you what town it was, where the commission adopted a motion for denial, and then in the ensuing week, the town attorney and the town planner rewrote it to read better, to be stronger. All right? No, you can't do that. Right? Whatever they adopt, that's what it is. If you're making stipulations or conditions, be specific about them. This is especially true for ZBAs. ZBAs are allowed to condition a variance on certain things that improve the compliance of the variance with the harmony and spirit of the regulations, but be specific. We went through extensive litigation in one of my client towns because the ZBA had granted a variance to a B&B, a local B&B, to hold intimate teas, parties, and other events. Well, what's that, okay? They started doing weddings for 150 people. And the neighbors complained, and the zoning officer said, I don't think that's T's intimate events and other, well, the developer owner said, and other events, other, this is other, okay? And the ZBA, by the way, agreed. The ZBA agreed that that's what they meant. They meant weddings for 100 plus people in this half-acre piece of land, okay? But it all could have been avoided if the ZBA had just been clear on what it is that they meant. There's another case called Dodson's Boatyard versus Stonington ZBA, where Dodson's came in for a side yard variance to build this little tiny addition to one of their boat sheds. And the ZBA looked at that little tiny addition and they said, basically, application for a variance to reduce setback to 6 feet, granted. Granted. You know what's coming, right?
Yeah.
Next Dodson's comes, they build a little, then they come in to expand the entire boat shed. The building's like 250 feet long, to bring the whole thing within 6 feet of the sideline. And the zoning officer says, no, wait a minute, that's not what the ZBA approved for you. And it reaches the appellate court, and the appellate court said, you said the side yard was reduced to 6 feet. You didn't condition it on that little building. You just said it was reduced to 6 feet. Okay, so you got to really watch those things. Remember that the approval that you're giving is to the application and not the applicant. The applicant may be somebody you've known your whole life and you trust and know would never do anything bad, but he can step off a curb to get hit by a bus, and his ne'er-do-well playboy son now has that application, right? So you've got to remember that. You cannot think of who's standing in front of you. So that approval will outlive you all. Yep.
Mark, if there's a condition like on a ZBA application that says, I don't know, you can't do something like maybe add a second floor on or something like that, and then the zoning regulations change that allow that to be done, is that still valid in your opinion, or?
The answer is clearly yes,
Yeah.
and there's a case on it.
Yeah.
There is a case where exactly that happened. Exactly that happened. Guy came in for a variance for a garage, to bring the garage closer to the side yard. And a neighbor showed up and said, you know, I really don't have a problem with this, but I don't want it to be a 2-story garage, because then the bonus room, that second story, will be looking right down into my backyard. And ZBA said, you know, good point, okay? So they approved the variance, subject to condition that it be only 1 story. Well, the applicant said that's not fair. This zone allows 2.5 stories. You limited me to 1 story. You had no right to do that. And appeals. And the court upheld the zoning board of appeals. The court said, yes, you're allowed to have 2.5 stories.
If you meet setbacks.
If you meet the setback,
Good.
okay? You wanted to come closer to the side, and the board, in order to balance the interest, said, yes, you can go closer, but lower. They were allowed to do that. One of the things that people forget on ZBAs, there are 2 components of a variance. One is hardship. You've all heard that one, okay? As a hardship that is unique to the property, that is not characterized by other properties in the zone, that renders the property unusable, confiscatory, all sorts of other words. The second component of a variance, though, is that the granting of the variance would be in harmony with the purpose and spirit of the regulations. So, if somebody has an undersized lot, and they've got wetlands and ledge, and they can't put any kind of decent house on there without some kind of variance, all right, and they come in for a 800 square foot Cape Cod, okay, ZBA could say, you have hardship, yes, we'll grant you variance. But if somebody comes in the same lot and wants a 5,000 square foot McMansion, ZBA could say, you still have hardship because it's undersized and ledge and blah, blah. But the purpose and spirit of the regulations is not that you have this, 5,000 square foot house on a substandard lot. So no, we're not, even though we find hardship, we're not going to grant you this variance. So keep in mind both of those principles. And lastly, if you defeat a motion to approve, that is a denial. You have acted, you're done. But if you defeat a motion to deny, you haven't acted yet. You haven't voted, okay? Many lawyers will tell you to always put a motion in the affirmative, that is to always make a motion to approve. I think that's not correct, okay? The reason they're telling you that is so that if the motion fails to carry, you've acted and you're done, right? But I don't see anything wrong with a motion to deny as long as you know it's going to carry, all right? That's another reason to have some discussion. Find out how the commission members are feeling. Is it tending toward approval or denial? If approval with conditions, what might the conditions be? So on. Okay? Be prepared. Review the materials that have been filed. Review your own regulation. I was at a zoning commission meeting once where I cited to a particular section, and I said to the members of the commission, if you take a look at page 36 and section, and none of them had a copy of their zoning regulations with them. That is not good, okay? Every commission member, and this is something for staff, when a new commission member is appointed, give everybody a zoning book, a subdivision book, maybe minutes for the last 6 months, whatever. There are, I'll mention, there are training opportunities. Connecticut Land Use Education and Research does them a few times a year under their base in Haddam. The Bar Association does them at Wesleyan, which Steve spoke of. That's once every 2 years. It is now set for March. If the 26th is a Saturday, 2019, it is already scheduled, okay? And we'll be sending out save the dates to people for March 2019. It's only once every 2 years. If you've not been to that, it is worth it. It's a full day of more information than you could possibly hold. View the property if it's something that you need to see. Have regs that say what you mean, what you want them to say. When in doubt, call your town attorney. I will tell you, all of my client towns have my home phone, my cell phone. I think your town attorney will say the same thing to you. If you're in that moment of the meeting where all hell is breaking loose and you don't know what to do, call a 5-minute recess, call the town attorney. Most town attorneys would much rather have you phone and know what to do than kind of, slog ahead and maybe screw it up. Like for my towns, any time of the day or night, they all know that. So that's your public hearing procedures. I'm going to take a few minutes on predetermination and conflict of interest, which I don't have a PowerPoint for. There is one, but it's another hour, and I don't know if you're ready for that. Okay. I can, but I don't. You are. Connecticut General Statutes 8-1 for zoning, and then there's also one for wetlands. The requirement in the statute is that a commission member should not participate in a matter in which they have a personal or financial interest. Personal or financial interest. The courts have added on to that it is just as bad for there to be the appearance of conflict as for there to be the actual conflict. The courts have said that the power of a land use commission over people's property rights is so great that people should have confidence that those decisions are being made fairly and based on regulations and based on facts. So if there's even the appearance of conflict, the courts will throw out the decision. So financial interest, that you are an investor in the project, that you live next door, a lot of ways you could have a financial interest. It obviously is a matter of degree. If you own 20 shares of General Motors and there's a proposed Chevy dealership, that is hardly going to affect the value of your shares of General Motors stock, right? So one of the things that I always advise to commissions is, first of all, always disclose the potential conflict. Judges do not like the hidden conflict. It makes them uncomfortable. So if you say on the record, I just want to state, I live 3/4 of a mile from this proposed facility. I don't typically drive by it. I can't see it from my house. And I believe I can participate in this matter without respect to that proximity. You've said two things. First, you disclosed it. You disclosed where you lived. That's number one. The second magic words in that phrase were, and I can vote on this without respect to that fact. The law is that if you say on the record, I can be objective, a challenger must prove that you weren't. That is not easy to do in many cases, okay? So, disclose it. Brance's rule is, when in doubt, get out, okay? If you're not sure, disqualify yourself. Trust your colleagues that they'll do the right thing. Without you, no one is indispensable. But the other thing, sort of exception to this, I guess you'd call it, courts do recognize a different kind of conflict of interest for community memberships. One of the seminal cases here involved a softball field. A member of the commission was also a member of the Little League Board of Directors. And an opponent of the Little League feels that he has a conflict of interest. He's on the Little League board, the Little League is proposing this field, he's on the commission, he can't be objective. And the guy said, I can be objective, I have no financial interest, I'm just one member of a large board, I have a kid who plays Little League, you know? So that went to court, and it was a Superior Court. It was a case out of Haddam. The Superior Court ruled that that was not a conflict of interest. And they had several reasons for that. First of all, they said, and you will all enjoy this. Some judges really are pretty smart. The judge said, it is typical that people who are involved in their communities are involved in lots of things in their communities. People who are on the Chamber of Commerce are also on the Planning and Zoning Commission, they're on the Little League, and they're on the church board. That tends to happen. 10% of the people do 90% of the work in most New England towns, right? The judge recognized that. People who are active in lots of things. Second of all, there was no profit motive. Little League is non-profit. So by definition, a member of the board can't make any money out of it because board members of nonprofits aren't allowed to make money, period, right? And so the judge said this was allowable. We had another case out of Old Lyme where the applicant was the local Roman Catholic Church. The commission chairman was not a member of that church, but his wife was on the Board of Deacons. And again, the claim was, he has an interest. And again, the court said no. First of all, it was just his wife, not him, but regardless, it's a church. I'm counsel in the town of Eastford. If we had an application from the First Congregational Church of Eastford, and if that was a conflict, if it was, we would not have a quorum of one single board in the entire town of Eastford. Literally, that is literally true. Okay, so courts recognize that. All right, so those kinds of conflicts the courts will deal with differently. Then the other one then is personal interest. Okay, personal interest. Your ex-wife, your wife. One of the cases that came out of Marlborough was where the commissioner's wife was filing for a subdivision. And he disqualified himself. And then he sat in the front row as close as you and I are and glared, at the commission members. Court held no. You were giving him the hairy eyeball. Then you should have left the room or something. You were pressuring your colleagues by sitting so close and staring them down. So that's personal interest. It's some animosity, some close friendship, right? Those are situations where you would want to disqualify. Predetermination is different. Again, I mentioned this earlier. It's where your mind is made up. One of my favorite stories about this was I'd been a town planner for, I guess, a year, and Dunkin' Donuts came in with their old style building that fortunately you don't see anymore. It was this purple and white plastic thing with glass, and it was a pre-application meeting, and it was getting late. People were getting a little tired, a little edgy, okay, and the commission was being very unwelcoming to this proposal. And at a certain point, the regional director for Dunkin' Donuts lost his temper, and he jumped up and he shouted, "I don't think you people understand. We build these all over the country. Are you saying we're not going to build one here?" Whereupon one of the commissioners lost his temper and said, "I think it's you that don't understand. We don't want your lavender and white plastic building on our main street." That's probably predetermination. Okay. So one of the commission members, who was an attorney, not his own attorney, but a sharp guy, he said, "I believe what Commissioner Gordon means is that you could pursue this application, but the road to approval could be very long, very steep, and might ultimately be unsuccessful. Isn't that what you meant, Commissioner Gordon? And Gordon said, yes, that's just what I meant, okay? Something that I have done is to give what in trial, in jury trials is called a curative instruction. We had a case in Middlefield where after the close of the public hearing, the developer put a full-page ad in the local paper extolling why the commission should approve it. The whole hearing was closed. So when we went for deliberations, first of all, how many of you saw the article? Well, out of 7 of them, 3 of them hadn't seen it. So those 3 are okay. Of the 4 of you that saw it, can you disregard what you saw in it? And all 4 of them said, yes, I can and will disregard what I saw. Went up on appeal. The challenged that. The court said, they said that they weren't influenced by it. I have no reason to disbelieve them. I read the article. All it does is summarize information that was already stated at the public hearing. There was no new information. It was just a wrap-up. So she upheld that decision. Excellent judge, by the way. But I think that part of it was that they stated, for the ones that had seen it, I can disregard that, and I will. And they did, by the way, they did. Be aware of those kinds of predetermination or ex parte communications. Very difficult in a small town. People will come up to you in a grocery store or wherever, and they want to talk to you about this pending application. And you just have to, I'm not allowed to have these kinds of conversations. I'm really sorry. We're going to have a public hearing. Please come to the public hearing. Well, I can't make it. I'm going to be on vacation. Well, you can write a letter. When I was on the commission in Glastonbury, I would say to people, I'm just one vote. So you should come to the hearing, you should write a letter summarizing these points so everyone hears what you have to say. It was a nice way of trying to, avoid it. We had one very controversial application where I got a phone call at home from someone I knew who wanted to talk to me about this one application. I said, I'm not allowed to. I went through the whole spiel with him. You should write a letter or come to the hearing. No. And I said, listen, I'm really not allowed to talk to you about this. I'm not allowed to discuss this with you. I'm very sorry. And the guy got really mad. He said, I've called every member of the commission, and they all told me the same thing. Good. And I was like, thank God. All right. They all got it, Very proud of my colleagues. So that's a short version of conflict of interest and prejudgment.
What's the deal with conflicts with business owners in the community that have financial interest with lots of people in town? Maybe small financial interest, maybe large, $1,000 financial interest.
Well, by interest,
To sell people things.
Well,
Various people. I don't want to
financial interest, if you're like a partner in the business, clearly that's a conflict of interest, even if you're one of 10 partners, okay? But things like being a patron, we had an application for our local Ace Hardware store. I shop there all the time. We all do. Is that a conflict of interest if you shop there, if you know the people? I mean, in small towns, you just can't go that far.
Right.
It gets crazy. And again, the courts are pretty good at, because the courts recognize that. The courts understand that they're small towns. And again, on the I am a customer of this place, okay? I'll tell you one case that I think illustrates this in sort of an interesting way. This is an actual court case, appellate court case, where one of the members of the commission was a paving contractor, okay? He voted on subdivisions. Sometimes he would put a bid on to pave the streets in those subdivisions. Sometimes he didn't, depending on how busy he was or whatever, okay? One particular subdivision comes in, he votes in favor of it. He later on, on appeal, he says, I really hadn't decided whether I'd put a bid in on that subdivision or not. I don't know. Sometimes I do, sometimes I don't, okay? In that case, the court held that it was a conflict of interest. They said the fact that he sometimes does bid on subdivisions that he voted on creates the impression that, you know, I'll vote for you, you hire me for the paving work, you know, that it did not pass the smell test. Now, the reason I point that one out is that at the time that decision came down, one of my client commissions had a chairman who was a paving contractor. And this guy was as ruthlessly fair and objective as you will find anywhere. And it was like, but sometimes he did, and he stepped down. You know, he let it, I think his term expired, he didn't go back because he knew about the case. It was kind of too bad because he was very fair, and the guy was highly regarded. So that can happen. I mean, if you're going to be doing another one, this I won't tell you what town this was, where one of the commission members does cabinets, kitchen cabinets, and people he'd vote in favor of subdivisions, and then they'd hire him for the cabinets. Now, you know, that may not have been why he did it. A variance is something that is not allowed in the zone. Right? That's where you need hardship and where there has to be harmony with the purpose and spirit of the regulations. I will tell you that recent case law has made it almost impossible to grant a legal variance. That doesn't mean you shouldn't do it. I will tell you that the Planning and Zoning section of the Bar Association that I'm involved in, we have a task force now that's looking to rewrite the statutes on variances. The way the courts have interpreted the variance rule, you'll just never be able to issue variances. And I think they've gone too far. And I think most practitioners feel that the courts have gone too far. Sometimes the courts aren't practical. The U.S. Supreme Court cases refer to the Zoning Board of Appeals as the safety valve of zoning. And I think that's a very good way to think of it, okay? When you divide a town up into zones and you set criteria for those zones, you're thinking generally. Inevitably, there will be pieces of land that don't fit what you kind of thought that zone could support. It's going to happen, right? And the ZBA provides that flexibility to say, okay, when the zoners drafted the regs, when they drew the map, they probably didn't foresee a situation like this. So let's do the common sense thing, all right? Well, the courts have told you you can't do the common sense thing anymore, right? And again, I'm not telling you not to. I think it's the courts that are wrong and not you. And we'll try to fix it. We'll do our best to fix it. Questions? I covered a lot. Steve?
Is there ever an excuse or a reason for a variance for something like a garage or a shed? Question A. And B, how far can you go and what should you look at, this is mainly for the commission members, for handicapped improvements? And we did do some improvements to allow some of those by right, but
Yes.
let's say somebody needs something bigger, a bigger bathroom or a bigger bedroom or a garage because they can't deal with the snow, you know, some things like that. Talk a little bit about that.
You covered, you blurred too far there. Let's go back. Okay. Can you have a hardship for a shed or a garage under the current case law? Probably not. There is one class of variances that has survived that the courts do uphold consistently, and that is where you are reducing a nonconformity. So, if a property is too close to the line, and you propose to demolish a piece of it but make another piece taller someplace else, the courts have said you can do that. You can if you're reducing a nonconformity, that is grounds for a variance, kind of a trade-off. So where you get that, and you may get that, by the way, in your lake area. That's a common area where somebody has lots of nonconformities and where they'll reduce one in order to get a variance from something else. Okay, so that is still a legal ground for a variance. The other thing that is not addressed in statutes at all and is not addressed yet in case law is the Americans with Disabilities Act and the Fair Housing Act, and variances as a way of recognizing the needs of disabled persons. Federal law has said since the 1990s that local regulations, and that means fire, building, zoning, okay, all regulations, must make a reasonable modification. By the way, you've all heard the term reasonable accommodation. That's for restaurants and people like that, okay? For you, the term is reasonable modification, right? You are mandated to make a reasonable modification of your regulations for the needs of disabled persons. It is my opinion, and I think you'll find the opinion of most town attorneys, is that variances based on the ADA are allowable, in fact mandated by federal law. The other thing that's sort of an interesting question is, I told you before that all approvals run with the land, but if someone comes in for a variance based on a personal disability, can you say, yes, that variance is granted for so long as a disabled person lives in that house, but thereafter it must be removed? I think you could. This is one of the things that our task force wants to address specifically, so that you have some guidance here. Like everything in law, it's moving slowly, but we'll get to it. The thing, when you grant variances for disabled persons, you're not operating under state law at all. You're operating under federal law. Some towns put in their regulations, and I recommend this, that the zoning enforcement officer may grant modifications for the needs of disabled persons. So you don't send them to the ZBA. You don't have a public hearing. You just take care of it, right? They do that in New Haven. And they do that in New Haven because New Haven got sued under ADA, FHA, and lost. And that was part of the settlement, was that they have to have a disabled person advocate who has the authority to waive any building code, housing code, zoning reg, anything. She can just waive anything at all in the city of New Haven, and she does. All the time. Sir?
I have a question. If you, like when you tear down like a piece of property or a house, and then you replace, the footprint's going to be a little bit smaller, and you're starting to use these impervious pavers, and you're going to say that we're going to be taking this away and we're going to be replacing it with the impervious paver, and now the footprint is going to be smaller. With the impervious pavers, I have some kind of an issue there, how effective they could be around like Highland Lake with the amount of water that's supposed to go through the cracks, and last time we had a meeting, it's hard to make sometimes a decision.
This is, you say, this is wetlands, this is ZBA?
ZBA.
ZBA, okay.
ZBA saying that I don't exactly know how these pavers are going to be as part of the project when the individual wants to tear down the old house, get rid of the asphalt, build a giant house, which is maybe 2 or 3 stories versus 1 story, and now his footprint's still going to be the same, and he's going to be taking up less land usage.
Okay, there's a couple of questions in there. First of all, let's start with let's put the pavers question aside.
Yes.
The first thing is, someone wants to tear down a house, presumably non-conforming
Right.
house, okay, and build new. I think it's pretty uniform across Connecticut. Towns said that if you voluntarily demolish a house, you voluntarily give up the non-conformity, okay? And anything new that you build must comply or get variances, okay? That's pretty standard around the state.
Right.
Was. It isn't now. Because your General Assembly has been in session, Public Act is, I think, 1738, don't hold me to that number, but new Public Act in the last General Assembly now says that if someone voluntarily demolishes a non-conforming structure, they can, and at no 1 year limit, no time, they can rebuild it to the same volume, now not bigger, they can rebuild it to the same volume without variances, right?
Okay.
So, and the reason, by the way, that didn't come out of places like Highland Lake, that came out of the coast, all right, where the new FEMA requirements require houses to be so extensively redesigned and rebuilt. What was happening was you can't fix up the cottage on the beach and meet FEMA. Okay, you have to demolish it. And towns were saying, oh, you demolish it, now you have to meet current zoning, which was impossible. Okay, so in order to encourage FEMA compliance, the General Assembly said, okay, if you demolish and rebuild to the same footprint and volume, not just footprint and volume, you can do that with no variances. You can keep your old nonconformities, okay? So that's a change in the law that has nothing to do with case law. That's a change in the statutes. So people will be able to rebuild the same volume. If they want to increase, let's say, height, all right, number one is the harmony requirement of ZBA. You know, if they're asking you for variances, they're saying, look, I'm going to make the footprint a little smaller, but I'm going to make it 3.5 stories. Is that in harmony? Do you think that that's in the purpose and spirit of the regulation? You may well say no. You may say, look, I'm willing to let you rebuild. I'm willing to let you keep some of your nonconformity, your former nonconformity. I'm going to let you add a little volume. But no, I'm not. I know it's not in harmony with the purpose of the regulations to allow this shoebox on end, basically. Okay. Your third question had to do with pervious pavers, and that is a very timely question because just 2 months ago, the Connecticut Land Use Education Research at Haddam did a whole day seminar on low impact development and pervious pavers and pervious concrete and pervious bituminous, and I sat through a whole day of this, joyfully, by the way. To my surprise, they found that the pervious concrete is not doing very well. The fines of dust and sand plug those pores. 5 years into a pilot program at the Yukon Stores campus, they had 0 porosity in the pervious concrete. Okay, it had to be, the only way that works if it is not just vacuumed 4 times a year. There's a special machine you use that blasts water into the porous concrete and then vacuums it up as it,
Crazy.
no, I mean, nobody has this kind of equipment. You know, it's just not something most people are going to do. By comparison, they had an update on something called Jordan Cove. I don't know if any of you are familiar with this. This was a pilot program from 20 years ago, all right? They did a subdivision in Waterford, in the town of Waterford. They did half the subdivision with your standard, bituminous concrete, curbs, catch basins, pipe, the standard way. And the other half with the pavers and rain gardens and swales and so on. And for the last 20 years, they've been monitoring the water quality in the 2 halves of the subdivision to get some real data on the comparison between these 2 methods. One of the things that they noticed was that the pavers that were used on the upper half of Jordan Cove continue to infiltrate groundwater after 20 years with no maintenance at all. Annual street sweeping like you do on every road, okay? But no blasting with water and vacuums and all this kind of stuff. And they actually had slides where they showed water coming down a roof leader or melting snow going across these pavers and just disappearing. It was an interesting presentation, and by the way, they did put it on the website for CLEAR, Connecticut Land Use Education Research. They did put the slideshows from these presentations on there, so you won't get the narrative that goes with it, but you'll see the photos, and it really is interesting that after 20 years that those pavers really have worked.
And I'll just add, if you go down to Torrington, across from the police station, there's a parking lot, and they're in there, and you can go down there with a bucket of water and you can play and see that they do work.
So,
And they've been there for a few years.
so a question with respect, you said the pervious concrete. The pervious asphalt generally will hold up and continue to, as far as I know, if it's vacuumed once a year, basically pervious asphalt will maintain its porosity and continue to.
The pilot program they were looking at was pervious concrete in stores. They did not address the pervious bituminous. And I don't. Any of you, if you have the chance, at the next time you're in Hartford, in the state capitol, they have these. They have these demonstration plots. There's a patch of pervious concrete sidewalk. There's some pervious bituminous parking lot. There's some pavers. There's 3 different kinds of rain gardens and there's a brochure that comes in. So you can, in walking around a distance the size of this building, you can see all these different examples, okay, and there's also green roof that you can look at. I got a tour of that by the engineer who was in charge of installing it. He raved about the pervious concrete sidewalks. He loved those. He said the pervious asphalt in the parking lot did not work for the aisles. Because in the summertime, as people turn into the parking space,
the aisles, yeah.
it tears it up, okay? He said what they should have done is use it only in the parking spaces. Because once you pull into a parking space, your wheels are straight and you're gonna back out straight, okay? You wouldn't have that problem. Whenever I go on vacation, you know, other people take pictures of lots of, my wife always chuckles at me, I take pictures of parking lots, you know, and gas stations and all kinds of things. And I just got back from a trip to Portugal, and I have all these photographs of parking lots using different kinds of pavers and different surfaces. They're way ahead of us in Europe on that stuff.
I parked my car here.
No, I just took pictures of the parking lot. But yeah, it's so they did not study the pervious bituminous at that seminar.
I mean, another place where it is Fitzgerald's supermarket in Simsbury, if you ever want to go there.
Simsbury, okay. And has that worked pretty well?
It's held up.
Good. I mean, the pervious concrete at Yukon held up fine.
No, but I mean as far as,
It just got plugged.
I mean as far as taking the water. that's-
Why would the concrete behave so differently from the bituminous?
Probably because the floor runner's line. I'm a civil engineer.
Okay, I figured you had to.
But yeah, because the floor runner's line. I mean,
Okay,
the
all right.
The asphalt's pretty
you can have
coarse.
larger- You can have
Pretty
larger
quick to
floors.
get.
and so-
In the asphalt, okay.
So you can, one, you can vacuum it up better, and two, if it doesn't, it can go through better.
Because one of the things that, and I forget the speaker, you probably know him, he said that they found it after 5 years at Gamble Pavilion, they had zero
Yeah.
porosity. Zero porosity from porous concrete. That's pretty bad. You know.
But another issue, just while we're on the subject of that kind of stuff, is also how to deal with gravel parking lots with respect to that kind of stuff, because you'll always get engineers who want to tell you the gravel is pervious. Well, it is pervious.
It is pervious.
It's pervious compared to clay. So if you're putting a gravel parking lot over a clay lot, you can count it as pervious. If you're putting a gravel parking lot over, regular sand or gravel or something like that, you're not going to get nearly the amount of water through it that you are through the existing soil. So you kind of have to, somehow in your regulations, look to go to some point like that where how you deal with it in terms of what its actual porosity is compared to the existing soil.
Most zoning regulations have two categories: pervious and impervious.
Right.
Okay, but in fact, as you point out, there are different levels of porosity, of perviousness. Unfortunately, most zoning regs just don't try. They just don't try to cut it that fine. Most of your new LED regulations will simply give the commission some discretion to examine the porosity and examine the pre and post development condition and try to use some common sense. And the engineers are getting better at this too. When I was town planner in Glastonbury, our town engineer mandated that everything go into a concrete pipe, and it was 100%. And the town got sued twice, lost twice. In $1971, one of those was a $90,000 cost. Now, to put this in perspective, I had been trying to get the town to hire an environmental planner to help us review the environmental impacts of our development proposals. And at the time, we could hire someone highly qualified with a master's degree for $13,000 a year. Right? The council turned it down. Once they had this $90,000 judgment, 13 a year didn't seem so bad after all, okay? Don't want that to happen again. And we had another case, the Calamari case, where again, the engineer had, frustrating, the developer's engineer, way ahead of his time in the 70s, had called for dispersing the stormwater, and the town engineer ordered him to gather it all together and shoot it into the brook. And it shot into the brook, and it knocked out the dam of a farm pond downstream of the Calamares, who sued the town. And of course, the town's defense was, we weren't the design engineer. The developer was the design engineer.
You mandated it, though.
And the developer's engineer testified, here's what I submitted. Here's what he made me do. And we lost, all right? So things have come a long way. Most engineers today, thank God, are, have learned not to do that. I think even the DOT guys have gotten better, I hope. It's being recorded. But broadcast live, I didn't mean that. Other questions? Yes?
I wonder if you could speak to the role of alternates on land use boards and how they sit and listen and how they interact and what their eventual role would be.
That's a good question. The rule is that alternates can participate fully while the public hearing is open. Once you enter deliberations, once the hearing closes, you impanel the commission. I mean, let's suppose you've got 7 full commission members authorized and 1 is absent. Let's suppose you have 6 full members. You appoint 1 alternate. The other alternates cannot speak. Not a word. Hearing's closed. That panel of 7, 6 regular and 1 alternate, right, continues to be the panel until a decision is made. So suppose the matter is continued to next month, right, and full commissioner number 7 returns and wants to bump alternate. No. Once you start deliberations, the panel is frozen. Courts have compared this to the way juries work. I don't know if any of you have ever been on a jury, but a jury has full members and it has alternates, right? At the close of evidence, the judge sends the alternates home. They're gone. It's the same thing with you. So, if you have a controversial application and you're missing a couple regular members, don't start deliberations, all right? Reschedule it if you need, or pick 2 alternates and stick with it, right? But that's a piece a lot of people don't realize. They think that when the full member comes back, that they can bump the alternate, and once deliberations start, they can't. And again, the courts take the reasoning that you can't have the decision-making panel shifting week to week to week to week as full members come and alternates leave. Once you start to make a decision, that's it. Commission is fixed. The other thing about alternates is that they must be seated, the case law says, in rotation. Now, what exactly that means, there is some flexibility. Some commissions, let's say there's a full member absent, they'll appoint an alternate for the whole night. That's okay, right? Then the next meeting, you do the next one down, all right? Some commissions, they pick an alternate for item number 1 on the agenda, then the next alternate for item number 2. That's okay too. Both of those, whether you do it by the night or by the item, they're both in rotation, it doesn't matter. The thing you have to watch out for is to actually rotate them. I had one commission chairman, client, who rotated them, he said, he always seated them alphabetically. So alternate Abel was always voting, and alternate Zebra was never voting, right? That's not rotation, okay? One of the things that they do in Glassware, I think is kind of a good idea, is on each agenda, they list the full members, and they list the alternates. And what the secretary does is each agenda, she takes the last alternate name and puts it at the beginning. She just does that, each agenda, okay? So that when the chairman looks at his list of alternates, he can take them in the order that they are on the agenda, because he knows that the first name was the last name last month. You with me? All right? It's just a really easy way to keep track of it. So you don't have to go, were you here last time? Who voted? Do you remember who voted last? Yeah. The chairman you can just look at that list and you can see that each month, each meeting, they're being rotated for him. Sir?
Same topic, different question. So last meeting, we had a long public hearing. We spent 2.5 hours on this application. It got continued, the public hearing to the next, and we had an alternate set.
Okay?
Next meeting, it got continued just for one small item or something like that. The regular member comes back, says they...
Hearing's still open.
We're still open. The regular member comes back, says, I've listened to I can, do you seek the regular member for that, or do you have discretion, or is it automatic?
Yeah, if the hearing's open and the full member returns and says, I've listened to the recordings and I've reviewed the materials and I feel qualified to vote, then as a full member, they can bump the alternate. Yes, absolutely yes. Only once you bring the gavel down and it's time to make a decision. Yeah. And the reason, by the way, why alternates can participate then is twofold. One, because members of the public could even ask a question. Certainly an alternate should be able to. But also, if the alternate ends up voting and he had a question that he wasn't allowed to ask, now what? So from what I've seen from the case law, the alternates are allowed to participate like any other commission member until you reach the vote. And you brought up a good point too. If you are absent for a meeting, you listen to the recording, you review the material, and state on the record, Mr. Chairman, I want to state for the record, I was absent for the last session of the public hearing. I have listened to the recording, and I've reviewed the materials, and I am qualified to vote. This is just like conflict of interest. If somebody makes that statement, an appellant has to prove that it's not true. They have to prove that you didn't listen to the hearing. There was one Superior Court case, the sort of thing that keeps lawyers awake at night, where the commission member did exactly what he was supposed to do. I listened to the recording, and it turned out on appeal that the recording was blank. And so he could not have listened to it. Right? That's your nightmare, Please don't do that.
The same, you don't have a public hearing, but you've got like a site plan
Yep.
application. And you see it in alternate. Or you don't, you see it, let's say we don't, you've got 5 and 2 here.
Yep.
And we've got discussion for site plan. The alternates can participate in discussion during the whole process.
When it's tougher where there's no formal public hearing, as in a site plan, but what you should do, at a certain point, the chairman should say, okay, now, have we heard everything we want to hear from the applicant? Everybody have information. Okay, we're now in decision making. I'm seating Jones and Smith as alternates. Okay, so that you draw that line just sort of artificially.
Going back to the McKenzie thing.
Yes.
Hopefully I won't make it too long, but, so that, basically that case sort of had absolutely no criteria associated with what they call the waiver. It's obvious though that you can't write regulations for every circumstance. And not every circumstance you can't write a regulation for is a hardship. So there's got to be a way to create criteria where you can modify, I guess, what your standard regulation is, isn't there? That you can apply and say, well, under this circumstance, we can look at it this way.
There's a way. There's a way. Steve has heard me say this. My motto is, if you can dream it, I can draft it. Okay. There's a way. And for those of you who don't know, let me just brief some of these two cases. And it's interesting about these two cases because they're from the same town, the same project. Okay. It's a McDonald's. Okay. McDonald's is proposing a restaurant in Madison? Monroe. Okay. And they have a zoning regulation that requires a buffer, a landscaped buffer, between commercial zones and residential zones. And this property abuts a residential zone. McDonald's, as a competent outfit, brings in a plan that shows the required buffer. The regulation says the commission may waive the buffer. No criteria. May waive. Actually, the regulation says the commission can waive anything, not just the buffer.
It's all woods, I think, right?
Not yet. Not yet, Steve. We're getting there. Okay. So, next door neighbor comes in, the guy being buffered, all right, and says, "Look, I plan on seeking a rezoning of my property to commercial. So I don't really need the buffer. I don't really want it. I thank you very much, McDonald's, but I don't need it. I don't want it." So commission says, "Okay, we're going to waive it." So McDonald's goes back, they redesign, they take out the buffer. Commission approves it. Okay, Mr. McKenzie appeals. Mr. McKenzie is not the guy being buffered. He's somebody else, okay, who's being financed by Burger King. Okay? So, Mr. McKenzie brings his appeal, and the argument, here's the problem with that case, why I think it was a badly decided case. The court could have said this regulation is invalid because it has no criteria for waiver, but that is not what they said. What the court said was zoning commissions can't vary zoning regulations, period. That power lies exclusively in the Zoning Board of Appeals. Only the ZBA can do it. And by the way, under our recent case decisions, even they can't do it, but never mind. So the court says, as a matter of law, you can't waive things. And it had nothing to do with the lack of criteria. That is the problem. That would have been a good decision, but they didn't do that. They just said, you can't waive, period. Okay, fast forward a couple years. McDonald's goes back, okay, to Monroe. They file a new application. By this time, neighbor has rezoned his property to commercial. So they don't need the buffer that was at issue in McKenzie anyway, all right, because it only applies if it's a residential zone, not a residential use. But now there's another issue. In the back of the property, the zoning regulation says, there shall be a landscape buffer consisting of 6-foot white pines staggered 2 rows, staggered 10 feet or whatever, okay? Unless there is sufficient vegetation to provide a visual buffer. Okay? McDonald's points out that the area to the rear of the property is in fact heavily wooded, is also a wetland where they don't want to send landscaping trucks in to plant white pines on a double row staggered at 10 feet or whatever, okay, amidst the existing vegetation. So the commission says, our regulation requires that you plant white pines unless the area is sufficiently wooded. We find that it is wooded, and therefore you do not have to plant the white pines. San Sierra, another neighbor, also same funding source, San Sierra, okay, appeals and says, hey, this is McKenzie again. You guys are doing it again. You waived that landscape buffer. And this time, same appellate court, by the way, same panel, appellate court says, no, this is not a waiver. The regulation says you must plant white pines unless there is existing vegetation, and there was. That's not a waiver. So the workaround is when you draft your regulations, you state this is required unless these conditions exist. Right? That's not a waiver. And that's how you get around it. Isn't this fun? Other questions? Either I lost you terribly or made it so clear, or you've all had too much pizza? Well, it is my pleasure to do these. As you can tell, I have a blast doing them. I really have fun with this. I would just leave you with this thought. I don't get a commission on this. This is Connecticut land use law from municipal land use agencies, boards, and commissions. This is what we call the Wesleyan book. Okay, the Bar Association bookstore sells it for, I think, $55. That is the printing cost. All right, we subsidize this, everything but the paper and the printing. And it has chapters on variances. It's updated every 2 years. It's got every wetlands, 22A19 interventions, anything you can think of. The only thing I will say to you is I have a chapter in this on procedures. My chapter is updated constantly. All right, so if you need my chapter in this book, go to my profile at Halloran Sage and look at the version there. All right, this is from March of 2017. I've already updated it probably a dozen times. All right, so check that. The other chapters are not updated that way, but it really is a great resource. It's very readable, and I can be able to find that. If you afterwards tell me which case it was. Who was somebody wanted the name of the case? I can get that for you if you remind me what it was, because it's in here. Thank you for coming. Thank you for all your volunteer efforts. Thank you.